morning, everybody, and welcome to session 3 of these employment coffee briefings. I hope everybody had a good Christmas break and that you've hit the new year, well, running, really. We're already about a week in, aren't we? It seems silly to still be saying it. This is, as I say, the 3rd session. It is also the first session of 2 that are going to be looking at aspects of discrimination and equality law. I thought it was important to get onto the Equality Act fairly early in these sessions. We had mentioned them during the one on recruitment. We also mentioned them in the December session. And it is one of those things that I think so influences a lot of the decisions that we make as HR personnel, as business leaders when dealing with employees, that all of the future sessions are going to have some kind of discrimination content sat whether in the background or the foreground of them. So I thought we'd break it into 2 sessions. We'll touch on the protected characteristics today, and next month we will start to look at the specific unlawful conducts and what does and doesn't amount to actual discrimination. Well, actually, before we get underway, for those of you who may not have seen the news, whether on our website, through our newsletter, Dorset Biz, LinkedIn, wherever you get your local business news from, we do have some updates to the team. As those of you who know Fretton's quite well will be aware, we lost the former head of department, Paul Burton, at the end of last year. He moved on to other things. And as of the 1st of January this year, we have acquired, joined forces with Kemp's Employment Solicitors, which means we've got Michelle Kemp on board as a new partner and head of the employment team. So that makes her my new boss. Please say nice things. It also means we get Kate Fretton back as a consultant. From your point of view, it does mean there's now 3 of us in the team. So for those of you who are clients of ours, that can only be a good thing. For those of you who are not clients, you will start to see all 3 of us doing sessions together. Michelle or Kate may join me for some of these in the future. There's already marketing material out there for an in-person session next month, and there will be things in the future that we'll start to do together a bit more as well. That's our contact page. Obviously, all of those details are online, and a copy of this slide will go out anyway to everybody. So, let's get on topic. As I say, what I want to do in this session, I want it to be reasonably interactive if possible, partly because it will give my voice a rest, partly because you don't want to listen to me talk constantly for an hour or so. So what we are going to do, we will touch on a quick introduction to what the protected characteristics are, where they come from. Obviously, primarily we're talking about the Equality Act today. That's our big focus. And the focus of the session really around that is going to be how are they currently being applied in the tribunal, when are these things actually triggered, and what do they look like when they're presented as claims. Building into next month's session, as I say, which will then build more on how those actually amount to discriminatory acts when there is a problem. We'll touch on some stumbling points at the end, and as we go through some of the places where the various protected characteristics can be an issue, and then right at the end I'll just give a very quick legal update, because we will pick back up on what I mentioned at the end of the last session about changes to holiday pay calculations, entitlements and things like that. So I am going to ask for your involvement very early on, so please do jump in to the chat, into the Q&A nice and quickly for me, please. The first question that is going to come up for you all, how many protected characteristics are there? If I were to look at the beginning of the Equality Act, how many would I find? How many are set out? If it helps, I will give you a choice of, I don't know, 6, 7, 8, or 9. It's where I find out absolutely nobody's listening. Okay, got a couple of answers jumping in. Yeah, that's roughly what I'm expecting. 6, 7, 8, or 9. I've got a couple of 9s, a couple of 8s. Any advance on 9 or 8? No, I'm going to cut it there because I know there'll be at least one person looking it up. Here they are. So the protected characteristics do come, as I say, from the start of the Equality Act. There are 8 of them to answer my question. The protected characteristics are the traits an individual can have, which the law says we should protect from being discriminated against, ultimately. And there they are: age, disability, gender reassignment, marriage or civil partnership, the individual's race, religion or belief, their sex, or their sexual orientation. I suspect those of you, and I can see there's a handful who did it, said 9. If I'm wrong on what I'm about to say, please do correct me. But I suspect most of you were adding pregnancy to that list, and it's totally understandable why you did. I'm not going to touch on pregnancy for this session, and the reason for that is it's not technically one of the protected characteristics set out at the start of the legislation. There are various provisions later in the Equality Act that, to all intents and purposes, make it a protected characteristic, but it's not one of those ones that sits in the list. Other maternity rights, such as pay, leave, kit days, the redundancy protection, entitlements, etc., all come from places that aren't the Equality Act. It is entirely understandable and I think entirely correct in your head to think of pregnancy as if it were a protected characteristic, but technically it's not in this list at the start of the legislation, so I'm not going to touch on it today. That gives us our 8. And what we're going to do, we'll just spend the rest of the session cycling through these, seeing what really they're coming from, where they're sort of being used in the tribunal at the moment, and we'll touch on some case law around them as well. So we'll move straight on. Let's talk about age in the first instance. Again, discussion point for you. Please feel free to give me your opinion on this and whether it's potentially discriminatory. Where we're asking these questions, the question we're really asking is the protected characteristic of age triggered in this situation? Okay, so we're not interested in whether this is direct discrimination. We're not interested in whether this is harassment. We'll do all of that in the next session. I suppose the question really should be, is it potentially discriminatory? Is the characteristic of age triggered, where somebody might use a phrase like wet behind the ears or young whippersnapper? Couple of yeses cropping in. Got a no, that's interesting, that's fair enough. Yes, yes. Yes, yes. Good, good. I'm happy with yes. Yeah, absolutely. Short answer is yes, these things are potentially discriminatory. We do trigger age here. And funnily enough, it's a very specific case where one like this came up and some of those phrases we use. I've picked it because Cash Zone Camberley is about 100 yards that way of me. I could hang out my window and see their building. So in this case, well, you've got it there. Claimant was found to have been discriminated against because of a manager calling her a kid and a stroppy teenager. And you do get some interesting cases around this. Age is one of those that doesn't crop up very often in the employment tribunal, but when it does, they are actually quite interesting cases. The youngest one that I'm aware of was a very similar case to this, actually. I think it was a cafe worker or a gift shop worker, something like that, somebody who was doing a holiday job, basically, 14-year-old girl. And she was quite literally dismissed for being too young. Ran the case. In fact, her mother ran it on her behalf and did win a successful age discrimination claim ultimately. So yeah, you can be sacked for being too old. You can be sacked for being too young. These claims are successfully brought in the employment tribunal, and people do win them. And there we go. The definition that's given in the Equality Act itself is an individual in an age group, which is typical sort of UK legislation in being completely unhelpful or saying exactly what it needs to say at the same time. So as I was just saying, you can be too young, you can be too old for certain type of job or work. As with all of the protected characteristics, any jokes, comments or jibes based on them can amount to discrimination. And the bottom one is a common place where we see age discrimination as well. And again, it's one we'll touch on in next month's session in more detail. But there's a lot of established employment tribunal cases on this. and performance management process, particularly involving the NHS. And what you'll often find is that a claimant will tie in an age discrimination claim here if what they think is happening is basically you employer are telling me that I'm too old to be able to make use of the technology. And they'll sort of frame it around this stereotyping or this idea that has got into the performance management process that for some reason the individual can't cope purely because of their age. As I say, they don't crop up hugely often. This will be relevant to next month's session as well. And interestingly, age is the only form of protected characteristic where if you directly discriminate someone as a result of it, it can also be justified if necessary. That's how people like the police and the military will get away with having maximum age for recruits. But it is there, it does happen. We do have an aging workforce as well. That's always worth bearing in mind. And so the risk is there, particularly when you have diverse ages within a workplace. It's one of the risks of having a particularly diverse workforce in any of the protected characteristics is that you do increase the risk of discrimination simply by people saying the wrong thing at the wrong time. Okay, moving on from age, let's talk about the big one, disability. I will do an entirely separate session on disability in the future. This is very much a whistle-stop introduction to it, because of course disability is such a big area. But there's your question. If we think about them as 1, 2, 3, and 4, my question for you is, are the following potentially disabilities? Very conscious I've not given you the definition, so this is very much based on your own knowledge. Can all of these be disabilities? Is there a question mark over any of them? Are any of them definitely or any of them definitely not in anyone's opinion? So we've got stress, obsessive compulsive disorder, OCD, hay fever, and I put alcoholism at the end there. If it's easier to give an answer, please do call them 1, 2, 3, and 4. I'm not going to ask you to write out obsessive compulsive disorder in full just to answer my question. Got a few in there. We've got some yeses. We've got where you say 2 definitely, is that as in number 2 or 2 of them? We've got a perhaps not hay fever. Yeah, like that as an answer. All of them potentially are. That seems like a lawyer's answer. Again, 3 hay fever question mark, no. OCD, yes. 2 of them stress and OCD, 2. 1, 2, and 4, yes. 3 question mark. Okay. I'll let you keep coming in on those. What we'll do, let's talk through the definition, and then we can revisit that point and see if our view has changed on them. So this is my interpretation. This is how I think of Section 6, the definition of disability in the Equality Act. A mental or physical impairment. So this is allowing for both mental health conditions and naturally physical disabilities as well, which have a long-term and substantial impact on an individual's ability to carry out normal day-to-day activities. Yes, I've just seen that comment come in. The definition is so broad, it could include almost anything. It is a relatively low threshold, and you'll find that it's much easier to meet the definition of a disability for the purposes of the Equality Act than it is to convince, for example, the DWP that you're disabled. The complication with this definition is that the word impairment is used there, and then the following sort of subsections of the definition are almost the definition itself of an impairment. You've almost got this weird double definition going on here, because an impairment could be said to actually mean something that has a long-term and substantial impact. And that is where the majority of these cases are litigated, really. It's normally quite easy to show that you've got something that amounts to a mental or physical condition. Long-term has lasted 12 months, is likely to last 12 months or is terminal. And therefore we have often this debate about the impact on someone's ability to carry out normal day-to-day activities. And that's where we get this sort of very broad definition coming in, because where somebody develops a condition, the question is almost what could they normally do before that they can't now. Where somebody's got a lifelong condition, it's what could somebody be expected ordinarily to be able to do that this individual can't. And that does mean things like walking the dog, going to the gym, playing football, going shopping. But it's also so individualized that sometimes you will get very specific issues being raised in the tribunal. I had a case not too long ago where the question arose as to whether my client was disabled or not because she was still able to get on a horse. And the other side in that case seemed to struggle to understand that Paralympics was a thing. The test is about what the individual cannot do, not what they can. So you don't really get around it by saying they can do this, they can do that. I've put a bullet point on the bottom there, which funnily enough answers the question I've just had come in. There's a handful of conditions that automatically qualify. Blindness will almost always be treated as a disability. Cancer, HIV and MS are deemed to be disabilities from the moment of diagnosis. Cancer, it continues to be a disability even if you are in remission. You are considered to be disabled indefinitely from the point of diagnosis. Simple reason for this is that part of the case law around this definition, part of the statutory definition, is that you're taken at your absolute worst. So even if people are using aids, even if people are being treated, whether that's medicinal, therapeutic, counselling, whatever, the assumption is, what if that person didn't have that thing? What would this person be like in their worst case scenario? And that applies across the board. So with that in mind, let's jump back to our couple of definitions here. Most people were saying that OCD was almost definitely going to be deemed a disability. Yeah, again, subject to the impact on the individual's day-to-day life, I strongly suspect it would be, providing they have or are likely to be suffering for 12 months or so. Stress is always an interesting one. I've been a bit naughty putting it in for obvious reasons, and again, we could talk for a whole hour just on work-related stress. Stress in and of itself generally is not a disability. And the reason for this is the tribunals have been quite clear that stress is a normal human day-to-day reaction to the pressures that we experience in life. It's where that stress starts to tip into depression, anxiety, an identifiable condition that arises as a result of the stress, that we start to move into disability territory. What really isn't helped here, of course, is that every single one of us will have seen a footnote at some point that says stress and anxiety or stress and depression. And that's where you're going to have to start to be a little bit careful. I think the thing about stress that probably makes it struggle to reach this definition is if stress is lasting for 12 months or is likely to last for 12 months, there is probably some other underlying condition that we need to be attuned to. Stress alone is unlikely to be that consistent for that length of time. Hay fever, there's case law that says it isn't. And as someone who suffers from this, and as someone who had to sit exams while suffering from this, I do take objection to that. But every piece of case law I'm aware of where hay fever was attempted, it's been deemed no. I'm sure a lot of people will agree with me there that while you're suffering from it, it can absolutely feel like one of the most debilitating conditions on the planet. It is, and it really can be. But yeah, case law on this generally says no, partly because it's seasonal, and partly because I think they take the view that it doesn't actually affect people's day-to-day life for that sort of substantial and sustained period. Final one on there is alcoholism. I said on the other slide that there were a handful of things that are automatically deemed to be a disability. There are a handful of things that are by law, by the actual definitions in the Equality Act, deemed not to be. Reliance on drugs and or alcohol is one of them. A compulsion to steal, kleptomania, a compulsion to set fires, pyromania, are both excluded as well. That said, where you've got particularly, well, any of those conditions, as it were, what you need to again be attuned to is the fact that if somebody is an alcoholic, is taking drugs, is a pyromaniac, is a kleptomaniac, there is a good chance there is some other underlying condition or background's very likely mental health issue that could arise from or be causing the alcoholism, the drug dependence, etc., etc. So alcoholism of and by itself, no, but bear in mind there is probably some other condition in the background there that you want to be attuned to. Okay. Gender reassignment. Here's our discussion point. This is obviously a fairly contemporary one. Anybody who has been reading the news for about the last 5 years will have struggled to avoid the issue around gender reassignment and gender identity. So here's my question. Can someone who identifies as non-binary or transgender, but who is not undergoing some form of treatment for reassignment, be considered to be protected under this definition? Okay, so the specific protected characteristic here is gender reassignment. If we've got somebody who, and let's pick up on there, identifies as non-binary, so they're not necessarily recognizing that gender is always one or the other, that there's a fluidity to it. Could that person be protected even if they're not undergoing treatment? So they're not going through HRT, they're not about to undergo surgery, they're not going through the counselling process that people have to go through to legally change gender. Got some mixed answers here. I've got a handful of no's, a handful of yeses. Don't know is an acceptable answer. Couple more no's, couple more yeses. Okay, let those last few answers come in. Again, it's a slightly naughty question because there hasn't been an appellate level decision on this to categorically say one way or the other. We've had a couple of recent first instance decisions that have come through the employment tribunal. But here we go. Yes, this was broadly the case in Taylor and Jaguar Land Rover, which was sort of the big high-profile case on this. And I mean, that's sort of the explanation for it. The tribunal did recognise there is a potential spectrum of gender identity, and they spent a lot of time working over this word process that's in the definition that we'll come on to in a moment. This was a first instance decision. It was actually quite an unpleasant one. The claimant had suffered fairly sustained abuse. It wasn't just a case of wanting to be accommodated. It was actually a very, very unpleasant and abusive case, sort of across the board. Quite significant failings in Jaguar Land Rover's own internal policies on this. And the tribunal were particularly critical that Jaguar Land Rover had policies and procedures in place, but that nobody had ever read them. So there's a useful warning for you as well. And the reason the tribunal in this case got quite obsessed over the word process here is because this is the definition of gender reassignment. An individual is protected if they're proposing to undergo, is undergoing, or has undergone a process for the purpose of reassigning their sex. And what the tribunal ultimately concluded, as I indicated on the last slide there, is a process doesn't have to be medical or therapeutic in nature. It doesn't require medical supervision. So a process in theory could be communicating what their gender identity is, acting in a certain way that is not necessarily associated with their natal sex, the way they dress, the way they behave, the way they choose to identify themselves or ask other people to do so are all potentially valid processes based on this first instance decision. That could be changed on appeal. I don't believe the case was appealed, so at the moment that is the law in this particular instance. Another tribunal could reach completely the opposite decision. An appeal court could reach completely the opposite decision. But at the moment, we've got to assume that there is a risk that if you were to discriminate against an individual based on gender reassignment, that case would follow this one. It was a fairly comprehensive exercise that the tribunal went through here. They did actually start digging through parliamentary records to find out what people like the Attorney General at the time were saying in Parliament when the legislation was being drafted. And the impression they got from that was the process was not intended to mean medical procedure. Otherwise, Parliament would have used the phrase medical procedure. That one, therefore, potentially a bit of a surprise to people. We know, as I said at the start, gender reassignment and gender identity is a hot topic at the moment. It is a controversial one. It is not going to go away anytime soon. So do keep an eye on this one. Really can't predict where the law is likely to go. To answer the question that has just popped up in the chat, the question is, so you can say you're non-binary and fall under this protected characteristic? Yes, in theory. I think the onus would be on the claimant to prove that they were genuinely identifying that way. I don't think they're going to be able to turn up at work tomorrow, say, I identify as non-binary, you're discriminating against me, if it's not affecting their life more generally and they can't show that they are in fact living in that way. But no, there's no easy answer to this one yet. It is a very, very tricky one. If we want an entirely new dedicated session where I just look at this, I can try to do that. I can try to bring in a specialist, but it is absolutely not my area of expertise, not a case I've dealt with yet. I know it's an interesting one. Is there anybody who wants to ask anything on this? Because I will try my best to answer it. I cannot ask the question, what are we supposed to do about toilets? That came up in a previous training session, because that is something that you need to look at internally. No, fine. If there are any other questions on that, do stick them in the chat or the Q&A. I will try to revisit at the end if we have any particular points. Okay, let's move on to a completely different topic, marriage and civil partnership as a protected characteristic. Not one that crops up very often. We all hear about sex, race, disability claims in the press when they arise. Marriage and civil partnership, I'm not aware of much more than about 4 claims since 2010, when obviously it was introduced under the Equality Act. So here's my question. Does the protected trait of being married or in a civil partnership get engaged, pardon the pun, if the person is discriminated against because of the person they are married to? So to maybe give a categoric example here, let's say I enter into a same-sex marriage or civil partnership with somebody, and my boss decides to discriminate against me because they don't like gay men. That's the kind of thing we're driving at here. So does the status of being married or in a civil partnership with, for example, someone of the same sex trigger this protected characteristic? Yes, 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 yes. That's sex discrimination and or sexual orientation. Yeah, I can see the logic there. Anybody think no? Right, I'm going to give you another example as well that will come up in a second. Let's imagine you are a married couple who run a business together, and you're going through an acrimonious divorce. And the partner who feels they've come worse off in relation to how they deal with the business, the company itself, decides to claim marriage discrimination, i.e. you wouldn't have treated me in this way if we weren't married. Does that trigger the protected characteristic? It's ultimately the same question. It's because I'm married to this individual. What do we think of that one? Still getting yeses, still getting yeses. That's interesting. That's interesting. In both cases, the answer is no, and there is plenty of case law on this that says it's no. Both of those examples are 2 of the only cases that have been tested in the Employment Tribunal or the Employment Appeal Tribunal. So this was the company case justification, and what the Employment Appeal Tribunal there said, claimant was the wife of the CEO, she was dismissed. The EAT ruled that it wasn't because they were married, but because of the closeness of the relationship. It wouldn't matter if they were married, it wouldn't matter if they were cohabiting, it wouldn't matter if they were non-married partners. She would still have been treated in the same way. It is sort of the justification that the tribunal took here. Therefore, it wasn't because of the marriage as such. This does crop up occasionally, where you get these complex company matters that are also matrimonial, that are also employment, and people do try this argument, and it is established that ultimately it doesn't work. For this reason, the test for discrimination, as I've put at the end there, is it because of the marriage rather than to whom the individual is married? the same-sex couple argument that I used previously, quite right, whoever said it would potentially be sex or sexual orientation. Again, that was a case that was heard in relation to, I think it was a Church of England minister who entered a same-sex partnership, and his seniors, bishop, whatever it was locally, didn't like it, and he felt he was discriminated against. And again, what the tribunal ruled in that case was it's because he was married to a man, not because he's married. So yeah, to answer a couple of the questions that are popping up, it is quite literally about the status of being married or in a civil partnership. I strongly suspect that this is one of those protected characteristics that I'm going to word this very delicately, survived in 2010 when it probably didn't need to. I think it probably came from one of those much older pieces of legislation that were there when, for example, the moment a woman got married, her boss would sack her because it was quite right that her place was in the kitchen raising the family. And we're probably dealing with a piece of legislation that's 50 or 60 years out of date by now, but which made its way into the Equality Act in 2010. And that's borne out really by this definition. It is literally only the case that it applies to people who are married or in a civil partnership. Single people aren't protected, engaged people aren't protected, cohabiting couples aren't protected. Pausing my employment law lecture for a second here. If you do not take away anything else from today's session, please take this. There is no such thing as common law marriage in the UK. You don't acquire any rights by living together as if you were a married couple. Please know that, because it's useful to know, particularly for things like estates and divorce law. Moving on, it doesn't protect divorcees, and it doesn't protect, obviously related to that, civil partnerships that have now been dissolved. So yeah, and that's why we don't see this very often, because as you can probably imagine, it's almost impossible to prove. And probably, as I say, is just a hangover from this much older legislation designed to protect people who were dismissed immediately as they got married, in what was ultimately a case of sex discrimination, I would suggest anyway. Yeah, there you go, surprising one. As I say, I've only been aware of 3 or 4 cases. That one, the employment appeal case, I did know the lawyers who were involved in that one, which is why I was aware of it. But I do think there's only been about 4 or 5 cases of it that have got anywhere. Okay, let's move on to race. There were 2 questions I could have posed about race here. I decided to go with the more complicated one. I might pose the other one in a minute anyway. Does the immigration status of a migrant worker trigger the protected characteristic of race? I appreciate that's a slightly complex question, but if you ultimately break it down, I suppose the question we're asking is, am I discriminating on the basis of somebody's race if I don't employ them because of their immigration status? And for those of you saying no, I'm not going to suggest that you're wrong, but I will just throw this one back at you. I'm not asking, is it not discrimination because it would be illegal to employ them anyway, potentially? So this isn't a question about right to work checks, for example. In fact, assume they have the right to work, because of course somebody could still be settled, for example, have the right to work, and this question could arise then. Does that change your view? Yeah, still getting no's, but changing my mind there because of what I've just said. Yeah, that's fine. Feel free to change your mind. Welcome to the law. And a couple of very honest not sures or don't knows there. Yeah, I like those as well. Okay. The answer is basically not necessarily. Again, it's a naughty question I'm posing because it's a classic lawyer it depends situation. What the tribunals have said historically is that immigration status is not necessarily directly linked to race, colour, nationality, the things that define race under the Equality Act. So it can be a distinct issue. Immigration status is inherently tied to somebody's nationality or country of origin, potentially. So the facts can suggest a claim, but in isolation, simply the fact that they have a certain immigration status doesn't trigger race by itself. And that's sort of the view we take here. And to an extent, that's slightly logical, because somebody's immigration status 99% of the time will simply mean not British. That's going to, I mean, the automatic right to live and work in the UK is being born here. So somebody's immigration status, 99% of the time, the race would be not British. Well, that doesn't necessarily trigger the protected characteristic of race, because simply being not British doesn't by itself mean that there's a race situation being triggered, because you've got hundreds of other races, national identities that you could choose from. Flip that on its head, and if you've got a particularly diverse workforce where you do have people from multiple nations, different races, different ethnic, national backgrounds, one individual's immigration status is not necessarily going to trigger race either, because you can quite easily prove that you probably employ other people from that race, national origin, ethnic background, etc. So no, short answer, immigration by itself doesn't necessarily trigger race, but it could collectively. Where this does obviously overlap with right to work checks is it's important when you're doing right to work checks to check everybody. Don't just exclude people who are Caucasian, for example, because you assume they're British. I know nobody's doing that, but that is where that overlap happens and where you might have the risk of a discrimination claim. Fine. The other question that I was going to ask on race, and I'll just throw it out there because why not? Let's have a bit of fun. What about the four home nations? So I've just used the phrase British to describe anybody sort of from the UK or Northern Ireland, but can race be triggered if, for example, you work in an English firm or in the middle of the Six Nations, you are Welsh and you start getting abused for being so? Do the four home nations trigger the protected characteristic of race? I've immediately got a yes. Immediately got a handful of yeses. Anybody think no? Anybody think that we are collectively British and that therefore being English, Welsh, Northern Irish, I should say, Scottish doesn't apply? Not that I'm suggesting that would be your personal opinion. Does anybody think that's the legal position? Yeah. Yeah. Short answer is yeah, the majority of you who have answered are right. Yes, those four can. The Employment Tribunal have happily said that English, Scottish, Welsh, Northern Irish have got distinct enough national identities that they can fall within the definition. And it's because, there we go, the definition of race, this is sort of pulled from the Equality Act and case law itself. It does include colour, skin colour, nationality, ethnic origin, national origin. It's quite a broad definition. And a combination of UK case law and historic EU case law on their version of this has made it quite a broad definition. So yeah, you don't get away with defending this one by just saying no, you know, it can't be offensive, we're all British. Fine, let's move on from race to look at religion or belief. I haven't given a specific case study on this one because it is quite a complex area, and it's going to take long enough to explain how religion or belief is determined without having a question on it. So it's the protected characteristic of a religion or a philosophical belief. Religion means any religion, so that is a structured, organized religion, as well as those that are not. It is religions that believe in a god or gods or goddesses thereof. It also means a lack of religion or a faith which doesn't have a deity involved. So atheism is covered. Religions that believe in sort of life force rather than a distinct deity are all protected as well. Beyond that, then we also move into beliefs, which are religious, philosophical, even political beliefs, or a lack of belief in a certain thing. Most recently, there's been two areas where religion and belief have been particularly tested. One we will come on to later because it's the overlap with gender reassignment and gender identity. There were also a lot of cases around COVID vaccines that arose from religion or belief as well. Might touch on a few of those shortly. In order to qualify, I mean, a religion is quite easy. If somebody is a member of a known, established, structured, organized religion, that's quite self-explanatory. A belief has to satisfy various criteria to qualify. Ethical veganism, people may remember this case where it was deemed that somebody who followed a full lifestyle that was motivated by a belief in ethical veganism did have a protected philosophical belief. Various political views have been deemed to be philosophical beliefs. I think Scottish independence was protected at one point. I think a view that the BBC is supposed to be impartial was protected at one point. And so we get these quite diverse areas that can potentially be protected, even if it's not immediately obvious when you're dealing with them in the workplace. Again, going back to the one we were talking about a moment ago, I'll come on to it in more detail later, but the belief that gender is immutable has also been deemed a protected belief, causing a natural conflict with the gender reassignment position. So the current test for what is or is not a religion or belief was set out quite a while back now in a case called Granger and Nicholson. We call them the Granger criteria because as lawyers we're really creative like that. And this is pretty much the process that the tribunal has to go through to decide if somebody has a protected philosophical belief. The first one's quite useful, isn't it? They have to genuinely hold it. They can't have just come up with it for the purposes of having a legal claim. That should be self-explanatory. The second one there is where a lot of the sort of no jab, no job, I shouldn't have to have the vaccine cases started to fall down, that it was simply an opinion. And this is obviously quite a complicated one to look at because arguably there's not an easy line that one can draw between opinion, viewpoint, and belief. I wouldn't want to be the judge who had to apply these criteria to something that was quite deeply philosophical, I suppose. But yeah, the point is there, it's got to be based on either cogent fact, if somebody's going down sort of a more direct belief, so the medical data, for example, around the COVID vaccines, or there's got to be, overlapping with point 4 there, some sort of logical cogency if it's going to be a more philosophical or religious belief. Third one there, it's got to relate to a weighty and substantial aspect of human life and behaviour. They sort of treat 3 and 4 as combined a little bit here because they'll say if there's some seriousness, some cohesion, some importance in what you believe or what you stand for, then that will also impact quite significantly on your life and other people's lives. So going back to the ethical veganism question that we were sort of looking at a second ago, what they looked at there was the way the individual claimant conducted himself on a day-to-day basis that was reflective of the belief he claims to have. And I believe it was to the extent that he wouldn't use public transport in case the bus hit a bird or went through a swarm of insects. It really was that extreme for him, which was why it was deemed to be a protected belief. The last one is probably the most controversial on there, and without wanting to get into a huge debate about how the law works in this country and the EU, I think this one is problematic. I think it's problematic because ultimately a judge has to make the decision as to whether an individual's belief is worthy of respect in our society. The second half of that is one that the Americans will take particular objection to because, of course, their equivalent of this sort of religion, belief, free speech wouldn't have that caveat. It doesn't matter if what you say or believe in conflicts with someone else's rights, you're entitled to it. And this is the one that can be quite difficult. So again, where this one has been tested historically, you can tick the first 4 of them with a lot of political beliefs, but if that political belief is ultra-conservative white nationalism, the tribunal will probably say that it fails on that final point. They will say that certain aspects of that are perhaps not worthy of respect in a democratic society, and certainly conflict with the rights of other people. At the original tribunal, this last one is also where gender critical beliefs originally failed. And the tribunal originally said that the way the belief was being expressed conflicted with the rights of people who had particular gender identities. They were told that they were wrong, both at the Employment Appeal Tribunal in one case and, if I remember correctly, by the Court of Appeal in another. This is about holding the belief, not about your expression of them. And that is really the important takeaway from religion or belief. Somebody is entitled to have it. You cannot discriminate against somebody who has a valid religion or belief that meets this criteria. You can, however, potentially take action because of the way they express it. It's a very, very grey area at the moment, which I will come on to in more detail towards the end of the session. But for now, that's sort of all I want to say on it. Again, it's an overview because this is about identifying alarm bells and red flags rather than sort of doing a full lecture on religion and belief. Fortunately, I'm not going to touch much on sex discrimination because it's really not that complicated an issue, even with gender reassignment. It is the legal status of being either a man or a woman. We're not worried about gender reassignment for the purposes of a sex claim because it doesn't really overlap particularly well. Do bear in mind that if somebody has a legal gender recognition certificate, they are of the sex that that certificate says. Otherwise, it's exactly what we would expect. It is discriminating against somebody for being either a man or a woman. The majority of claims these days that seem to arise in this situation come in one of two places. Either they are equal pay claims, which isn't strictly a sort of protected characteristic claim. It's got other legislation around it. But actually, those equal pay claims that are about, they're largely the big supermarkets who are being criticised for paying cashiers, often women, less than warehouse staff, often men. The Equality Act actually requires more than that. Specific legislation for equal pay, what the Equality Act says is equality of terms. And that can be access to things in the workplace, promotion opportunities, benefits, all of those things as well. The other place we're increasingly starting to see sex claims, and I have brought one on this basis, is around the menopause. And what we've got is a handful of cases now that very distinctly say that the menopause is inherently an issue related to sex, because it is a woman-specific issue. Again, this is probably going to be complicated at some point in the future by sort of trans rights issues, but at the moment the tribunal are saying it is a women-specific issue, and therefore it can be brought as a sex discrimination case if somebody is discriminated against on the basis of experiencing the menopause. Again, I've got a session on menopause that I've done before. I think there's a recorded version of it somewhere available, probably on the firm's YouTube site. If not, there is plenty of stuff that I've written online. If you want me to do a session on the menopause in the future, I'm more than happy to do so. Okay, last one of the protected characteristics, sexual orientation. Here's your discussion point for this one. A gay man is treated less favourably than a lesbian woman. Could he bring a claim on the basis of sexual orientation? So this is quite an interesting one. Gay man is treated less favourably than a lesbian woman. Do we trigger sexual orientation here as a discrimination claim? Couple of yeses, 3, 4 yeses, 1 yes with question marks. I like that. Anybody think no? Anybody going to put their neck on the line and say no? Because I'm mostly getting yeses at the moment. Is that all I'm getting? Okay. Right. To answer this one, let's think about the definition. There we go. So here's the definition of sexual orientation. It is an individual's attraction to people of the same sex, people of the opposite sex, or people of the same or opposite sex, i.e., it is intended to protect homosexual people, heterosexual people, and bisexual people. And at the moment, that is it. Those of you with an online presence or with family or friends who have a particularly heavy online presence will probably be aware that much like the various gender definitions, there are also a huge number of different sexual orientations that are not simply homosexual, heterosexual, bisexual. The most obvious omission here that I think is recognised even if we ignore all of the others is that people who are completely asexual are not protected here. But it does, because of the way the Equality Act is worded, include perceived or assumed orientation. So as we will come on to when we look at the protected characteristics, a straight man who somebody assumes to be gay can bring a sexual orientation claim if he is abused using homophobic language. But if we think about our example of a gay man and a lesbian woman, they actually have the same trait. They are attracted to people of the same sex as them. And therefore, fundamentally, to a discrimination claim, there's no difference in these two people. And I appreciate that's quite an interesting one to get your head around, especially for people who very automatically said yes, but they've actually got the same traits. And therefore, you can't trigger sexual orientation because they both fall under that first definition, attraction to people of the same sex as them. This case, I believe, has been tested. It's certainly an example that's often used in the Equality Act to prove why this maybe doesn't make sense, because so many of us instinctively went, well, yes, of course it is. The treatment is ultimately down to their orientation. But yes, because of the way the Equality Act is worded, there's technically no difference between these two individuals. So here we go. Most of these cases predate the Equality Act, and it could be a sex discrimination claim in which you would say these two people are functionally identical. They have same-sex attraction, but the discrimination is because he's a man while she's a woman, and you could probably try that argument. And as I've said at the bottom there, would the answer be different if it was a bisexual man and a lesbian woman? Well, yes, maybe, because then under the three definitions that we're given, they've got different traits. She's attracted to people of the same sex, he's attracted to people of either the same or the opposite sex. Yes, so I mean, obviously the purpose of that, just to show how sexual orientation claims work. They are potentially quite complicated. And of course, this legislation is now 14 years old. The world is changing. There are gaps in the Equality Act, as we've picked up as we've gone through this. There are novel ideas that the Employment Tribunal has to pick up quite regularly. It's one of the reasons I particularly love employment law, I have to say, because we get all of these novel cases very early on. And it is very easy to trigger one of these without meaning to. But equally, as we've seen as we've gone through, there's certain times where you think, yes, that must obviously be that form of discrimination, that protected characteristic triggered, but it's not always the case. So let's talk very quickly on overlapping claims. What happens if two or more people trigger two or more protected characteristics? What happens if someone's expression of their gender or sexual orientation clash with someone else's religious or ethical beliefs? Well, we end up with a problem, and I can't give you a clear answer to this. And the reason I can't give you a clear answer to this is because of one of the biggest problems with the Equality Act. There's no hierarchy. These protected characteristics are all considered of equal value. We don't get to say that disability, something that objectively somebody can't help being, matters more or should have a higher status of protection than, for example, somebody's religious belief and how they express it. The tribunal has no way of looking at the Equality Act and saying this right has to take priority over this one. The only way they can do that is in relation to the religion or belief, by looking at that, does it interfere with the rights of other people question right at the end. The problem with that is, of course, we're a country that claims to have free speech. And this is where a lot of these expression of that religion or belief are conflicting with gender identity. These cases will resolve themselves. An answer will come up eventually, probably as we get more used to particularly people of different gender identities being in public, being in the workplace, being known to us. And it's exactly the same issue that has existed throughout history. People of different ethnic backgrounds coming into the workplace, and the issues around that have ultimately slowly started to resolve themselves. Women in the workplace versus someone's belief that they shouldn't be have started to resolve themselves. And moving sort of into the last 30 or 40 years, gay, lesbian, bisexual people coming out in the workplace and being openly so, and conflicting with religious rights. The trans issue is just the next extension of that. It will take its time to sort itself out. But for the time being, we have this complication in the Equality Act that tells us realistically, you don't have an answer. You've got two conflicting rights that as an employer, you are obliged to protect your staff over. If you find yourself in that clash situation, all I can say is take advice, because you are absolutely stuck. You are legally obliged to take both protected characteristics into account when they're both triggered. Again, we can look at more of that in future sessions. Okay, absolute last thing I want to touch on very quickly. In the December session, I talked about a couple of changes that were coming up at the start of this year. Here they are. The government has issued some guidance on the holiday pay claims. This is a very brief summary of it. There are pages and pages and pages of it on the government website now. But in short, if your leave year begins on or after the 1st of April this year, for irregular and part-year workers, you can go back to using 12.07% to calculate holiday entitlement. Happy days, much easier. I mentioned in that session that certain carryover rights for holiday are going to be protected so that we don't accidentally revoke them at any point in the next few years. So if somebody does not use their annual leave entitlement because they are otherwise on family leave, sickness absence, or because somehow as an employer you have obstructed or prevented them from taking that leave, they roll over into the next year. Rolled up holiday, I should say, will also now be allowed for holiday years that start on or after the 1st of April. Somebody asked in the last session if I could give a definition of rolled up holiday. I have put it at the bottom of that slide there. In effect, it is when you have got somebody employed, usually on a short fixed term contract, so summer staff to run a camp, to work in your hospitality sector, to do your festivals, things like that. You make an additional payment into their pay slip that covers their holiday entitlement, so that if they take any, that day is in effect unpaid because they've already been paid it. The calculation will also be 12.07%, as long as they don't fall under minimum wage for the hours actually worked. This will now be allowed. I think the rules are probably going to remain that you still have to make it clear. They still have to know from their pay slip what is for time worked and what is holiday, but this should hopefully hugely simplify holiday calculations for irregular workers and part-year workers, and also cheer up a lot of people who were technically doing something illegal by having rolled up leave for the last few years. Okay, that's me done for today. Massive whistle stop, as I know, covering the protected characteristics. Hope you found the session useful, background update, whatever you were here for. Next session, I believe, will be Wednesday, the 7th of February, where I will go on to the next step of discrimination and equality. We'll start looking at some of the actual unlawful conduct. I've got no outstanding questions in the Q&A. It is 11 o'clock, so if people need to leave, completely understand. Thank you very much, everyone. Enjoy the rest of your day.